first mistake that business owners make when they're starting a business is that they don't form a separate business entity. So a lot of business owners have heard about limited liability companies and corporations, and they've heard about it, but they think, I don't need to take the time to form one of those. I have a business, I want to start operating, I'm going to save a few dollars and just start operating my business. So they end up operating as something called a sole proprietorship or as a general partnership. And then if something goes wrong with a partner in the business, or if the worst happens and there's some kind of lawsuit, they come to us and say, hey, how do I protect myself at this point? And quite frankly, at that point, it is too late to put those protections in place, when it would have been something that we could have done really easily by setting up an LLC or a corporation and getting that protection in place and making sure that you don't get in trouble with any partners or other parts of your business. Another problem that companies have is that they will actually form an entity. So they'll form a limited liability company, but they won't put in place an operating agreement. So they'll file articles with the Secretary of State, they'll get their tax ID number, and then they'll just start operating their business, which seems fine, except there's another document called an operating agreement. And the operating agreement is really the most important document for an LLC because it's the one that governs who gets to make the decisions in the company, which one of the members of the company has the power to sign on behalf of the company, who needs permission in order to take out a big bank loan for the company or make big decisions for the company. Having an operating agreement in place is a step that a lot of people will skip to save a few dollars, but it can make it hard to decide how to operate the business if you don't have that in place. Another thing that kind of surprises people when they don't have an operating agreement is that they're not going to be able to open a bank account, and they're not going to be able to get any loans without the operating agreement. So we'll have business owners that'll contact us and say, hey, I formed an LLC, but now I'm trying to get a loan from a bank, and the bank is saying I can't have one unless I have an operating agreement. And so at that point, they're able to put one in, but something could have gone wrong in the period prior to having the operating agreement in place. Another mistake that business owners make is that they don't follow corporate formalities. And what that means is that when you form an LLC or a corporation, even if it's just you, or even if it's just you and your best friend, you have to treat that LLC or corporation as though it's a separate entity. It's a legitimate business that's completely separate from you. So it's not the same as, Zach Wiggins is not the same as Zach Wiggins LLC. So I need to treat it as such. So my personal expenses that I need to pay, whether it's for my family or for shopping or groceries or whatever, I need to pay those out of my bank account, and I need to pay my company's expenses out of the company account. If you start using the company's bank account to pay your personal expenses, then you're essentially forfeiting all of the limited liability protections that you're trying to get by having the LLC, because you're treating it as your alter ego and not treating it as a separate legal entity. When a corporation is formed, there's bylaws and there's articles that are filed. The problem is, if you're in a corporation, there's no restrictions on transferring your stock. So if you and I are in business together and we both own the stock in a corporation, I can sell it to whoever I want without your permission. In order to stop something like that from happening, we put into place something called a buy-sell agreement or a shareholder agreement. And what that agreement is it says everybody that owns stock in this company is going to agree that the stock is subject to the following restrictions. If any of the following triggering events happens, then the company has the right to repurchase the stock, or the other stockholders have the right to purchase the stock, so that you don't end up in a position where you're in business with somebody that you don't want to be in business with. So there can be a lot of the triggering events that you put in, but some of the most common ones that we see are a stockholder's death, their disability, a divorce, bankruptcy, if you have creditors filing lawsuits against you, or if the IRS is coming after you. Believe it or not, the people that are in business and own stock in a corporation don't generally want to be in business with creditors or with the IRS. So in order to prevent that from happening, we put a buy-sell agreement or a shareholder agreement in place and make sure that that doesn't happen. One thing that businesses, after they get started and once they get to the level of some relative success, they need to put into place some kind of plan for their succession planning. Succession planning is figuring out what is going to happen to the business when I'm no longer involved in it. So how am I going to get it from my generation, myself, to the next generation, say my kids? how do I transition it from parents' generation to children's generation, and preferably in a way where I still have some control over it, because I want my children to be involved in it, but I want to transition the control over to make sure that it's a smooth transition. Sometimes we'll get phone calls from people that will say, hey, mom and dad had this really successful business, but they just passed away, and we don't have a clue how the business operates or who owns it, and we don't have anything in place to transition management from them to us. And it can be very, very difficult to dig into the company and figure out how that succession planning is going to happen. When, if you had planned ahead, it can be very, very easy to transition from one generation to the next generation, especially when your business starts to get to a pretty high value. It's possible that you're going to have to pay estate taxes or gift taxes. And with pre-planning on the succession plan, you can avoid the IRS to a large extent. But if you don't do any planning, then the IRS might get involved and you might end up having to sell the business just to pay your estate taxes. So it's important to figure out if that's going to be a problem, and if it is, how can we get ahead of it and make sure that it doesn't hurt the business going forward.